A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. I'll be talking with Second Amendment attorney Amy Bellantoni from New York. You know, we had Amy on the program last week talking about a case that she's been involved in where New York City actually has to pay damages to a guy who got the runaround back in the May issue days of permitting. And while we were talking with Amy, she mentioned that she's been doing some research in another case that has led to a deep dive on, the national tradition or the lack thereof of banning firearms in places where children are present. And this has come up in a number of cases. Most recently, or at least the one that I recall immediately, is the Seventh Circuit decision in Schoenthal versus Harul. But, even in the challenges to New York's Concealed Carry Improvement Act, in the challenges to New Jersey's Brew and Response Bill, and Maryland's Brew and Response Bill, we have seen courts, in this case would be the second, third, and the second, third, and fourth, although I think the Third Circuit is ultimately going to give us a better decision than the three-judge panel did, or at least the district court did, regarding sensitive places. But we have seen a number of courts around the country come to the conclusion that if kids are likely to be present, then it's sensitive. Then guns can be banned. And Amy Bellantoni says that's not what her research has shown the national tradition to be. So we delved into it. It was a great conversation. I really appreciate her joining us. I think it's, again, if you are interested in the history of our right to keep and bear arms, including the history of regulating that right, I think you'll enjoy this conversation. And I think, again, you'll be pleasantly surprised to learn that much of the evidence that anti-gun governments around the country have offered can be pretty easily debunked, and have been, by Bellantoni's research. Take a look and listen. Amy, thanks so much for coming on the program. It's good to see you again.
Great to see you too. Thanks for having me.
You bet. So when we were talking last week, I don't want to say we got sidetracked, but the conversation took a turn towards the research that you've been doing in terms of finding out, what do these sensitive places look like, particularly when there were kids around. And, unfortunately, on Monday, we saw the Supreme Court dismiss a challenge to the ban on concealed carry on public transportation in Illinois. This is a ban that was upheld by the Seventh Circuit that said, essentially, there's a tradition of banning firearms in, they said, all government buildings or government property, confined public spaces, and places where vulnerable populations like children may be present. And they said, the public transportation it checks all of those boxes. So, of course, you can ban guns there. Now, this is an issue that I think is coming up more and more frequently now, that vulnerable population phrase, right? Basically, anywhere kids might be present. If schools, are off limits because kids are there, well, then any place where a child might be or children might be, that too, we could just, analogize to a school and therefore ban concealed carry in those places, right?
Right.
At least that's the argument, how the argument goes.
Yeah, right. So this whole sensitive locations and vulnerable populations, when you look back at the history of sensitive locations, more particularly, and I'm just going to confine, my, words here today to the cases that I've worked on. More particularly, I had the opportunity to do some research in connection with a case I have pending in the Northern District of New York, Mintz versus James, which is a challenge to New York State's ban on firearms at summer camps. And so New York State analogized the summer camp ban to the analogies of, bans of school bans, and also to the crowded places bans as well. But we have to go back to basics here, and literally back to Heller and the recognition that the Second Amendment right is preexists any kind of government, so it's a natural right. It is an individual right, and so essentially, from my perspective, it follows me wherever I'm going. It doesn't, check itself once I leave my house. It doesn't cease to exist when I'm in a crowded area. And in looking back at, the Heller analysis, McDonald's analysis, Bruin's analysis, you know, situations that existed back at the founding, when the Second Amendment was ratified, if there was no ban or there was no similar regulation on firearms and weapons at that time, then there is no historical analog and it cannot justify a modern day regulation. So children existed back in the colonial times, crowds existed back in the colonial times, violence existed back in the colonial times, schools existed back in the colonial times, and there were no such bans at all. So in doing my research, I was fortunate enough to come across a 2019 piece that was written by Dave Coppell and Joseph Greenlee. It was published in the Southern Illinois University Law Journal, and it's actually titled Second Amendment Rights of Young Adults. And as part of that writing, the authors go into the history of, children at the time of all times, really, but most particularly relevant to my case, in the colonial eras, in the colonial era. And there's a piece here in their writing that speaks to Thomas Jefferson and how when he was 10 years old, his father basically gave him a gun and sent him off into the woods to, fend for himself and learn how to be independent. A story about militiamen on the way to Lexington and Concord when they encountered 8-year-old John Quincy Adams, who was the son of Abigail and John Adams, who was outside, and with his gun, engaging in marksmanship activities. And a quote from John Adams himself, who was going back to the times when he was a 9 or 10-year-old schoolboy, where he would leave his gun by the schoolhouse door so that when school was over, he could use it to go out hunting. I think that these modern day anti-gun liberal mentality of always going to the emotional argument and, our children, and we need to protect our children. That's not the way children were viewed back in the colonial times. It was a hard life. They were seen as little adults. They were not coddled as many people coddle their children today and stunt their emotional growth. And this, I feel like the whole past the late 1800s going into the 1900s, the whole movement toward making guns taboo, especially in the northern areas or in the city areas, maybe not so much in the southern or the rural areas, has really taken the gun culture out of the family, made everything taboo so that there's no knowledge of firearms, there's no respect for firearms, and that leads down the trail of, well, if something's taboo and we don't have access to it, now, we're not going to respect it. We're just going to be either we're not going to have any exposure to it, we're going to consider it evil, and it leads to a completely different mentality that quite frankly did not exist back in colonial times.
And I mean, and I realize, from a legal perspective, the Supreme Court wants to know, okay, what was the tradition 1791? Maybe what was the tradition around 1868? So when you get into the 1930s, 1940s, 1950s, even that is far too late, I think, for the Supreme Court to care much about it. But I remember talking with some folks, this was back in the NRA News days, who talked about, I remember one guy specifically talked about taking his .22 rifle on the subway in New York City on his way to high school because there was a range in the basement of his high school and he was on the high school rifle team. I remember another gentleman talking about how as a kid, he had saved his money. He was going to go buy himself a .22 rifle. He got to the gun store, and this was in the Cook County, Illinois, and the proprietor said, essentially, sorry, kid, they just passed a federal law, and you're not allowed to buy one anymore. There's a fascinating book. It came out, I guess, in the 1970s. It's called Gun Control, a written record of efforts to eliminate the private possession of firearms in America. And it's by a guy who was with the Illinois State Rifle Association at the time. And he went back and he, compiled a lot of the testimony in Congress leading up to the Gun Control Act of 1968. Going back to like 1962, when I think it was Senator Dodd from Connecticut had introduced a bill supposedly to deal with juvenile delinquency. And in this debate, I mean, I think it was even John Lindsay, who was, the liberal, went on to become the liberal Republican mayor of New York City, talked about, hey, listen, no one is trying to impact the rights of juveniles to exercise their right to keep their arms. I mean, it was taken as a given that even under 18s had access to their Second Amendment rights, at least in some regard. It was, again, we got the same language about we're just trying to, impose some common sense measures to prevent, criminal activity. But I was really struck that, even in the early 1960s, there was this presumption, A, that the Second Amendment protected an individual right, and B, that right extended at least to those who were considered legal adults. And it was not, I don't think it was particularly uncommon to believe that right actually extended to juveniles too.
Right. I mean, and then when we look at the camps that the high school rifle teams, which were prevalent and still are prevalent, even the New York State Legislature has a carve out for the possession of firearms on summer camps, summer camp property, school property, so that kids can engage in rifle competition. So one of my clients in this case, in the summer camp ban, he grew up in the city. He would bring his rifle on the bus with him when he went to school, and then would go to practice after school. So I feel like these new laws that are being passed are just examples of desperation, to just try and find any possible theory of disarming people or making people into criminals when really, I mean, and these are licensed individuals. So we're talking about, handguns can't be possessed there. New York requires a license. So you've already now vetted these people, subjected them to some discretionary moral character, requirement, and given them a license indicating that they're safe and eligible to possess handguns. And then you've told them, well, now you can't carry them anywhere. You can't possess them anywhere. This summer camp land is private land. Only 3 months out of the year is it used as a summer camp. The rest of the year, they hunt, they do target shooting. They're, shooting wild animals they have, livestock there that they're trying to keep alive. So I don't understand how once children get there, it suddenly makes the property unsafe, and these people unsafe to have firearms around them, when these are the people that are going to be protecting the children if, God forbid, there is an attack. And this land, this is, I might have mentioned to you before, this is a Jewish summer camp. And these people are in an upstate area that is very rural. We have a facial challenge and an as-applied challenge. The response time can be up to 35 minutes to an hour for the police to, get to their location. So if we're looking at another October 7th, God forbid, you can't just tell them run and hide. Can't be locked down, assuming that the school bans or even have a historical analog, which we can discuss as well.
Yeah.
This is not the same. This is not the same type of situation.
Yeah, and by the way, I didn't mean to suggest that your case is advocating for the campers themselves to be able to carry concealed firearms. Regardless of what was said back in the 1960s, I think that Overton window has shifted a little bit. But when it comes to adults, as you say, these adults who can carry in non-sensitive places, right? They've been deemed by the state of New York to be responsible enough to carry a firearm to protect themselves and others. It's just not in these particular locations. I think you mentioned this the last time you were on. When we talk about those historic analogs that the courts have pointed to regarding schools, even the judges say, okay, yeah, it wasn't a categorical ban, right? It was a ban on students possessing firearms. But it did not stop faculty members, visitors from carrying firearms on these school grounds. But they still use that as an analogy, right? They say, well, it doesn't have to be a historical twin. And it doesn't. But you can't just say, well, yeah, some people were banned from carrying guns in this place over here. So that means everybody can be banned from carrying guns in this place over here, right?
Right. And the only two examples, categorical examples that New York State came up with as their historical analogs were school bans and crowded places bans. So with regard to the school bans, and again, I'm just speaking to the analogs that were presented in my case by their expert. They didn't start until the late 1800s, I would say in 1870 and later. So they're already out of the realm of analogs going back to the 1791 or even, during the Civil War era. But that being said, they weren't criminal statutes. They weren't passed by a legislature. They were administrative rules, and they were for college kids. And a lot of the laws or a lot of the rules allowed the college students to seek permission from the college to be able to bring their firearms. But these were, rules to keep students in line. They included, no snowball throwing, no knives, no firecrackers. I mean, these are just general safety rules for school. They did not. I think maybe there were two rules from the colleges that prevented faculty from having firearms on campus, but for the majority of them, it was just the students. And they were college age. So yes, it's not an analogy to the general public, and it's not a criminal law. It didn't have criminal penalties. It was, you were suspended or maybe expelled if you brought these prohibited items into your school.
When it comes to the issue of these crowded public places, from what I've seen, courts generally start by citing the statute of Northampton, and they'll say, well, see, even back in the 1300s in England, there were prohibitions against carrying guns in, fairs and markets. And then they point to, I think there was a North Carolina law from the late 1600s. I think there was a Virginia law from the late 1600s that essentially copied the statute of Northampton. But a lot of times what I'm seeing is the court leaves out the fact that those prohibitions applied to those who were bearing arms with the intent to terrorize others, right? It wasn't just that, okay, no guns are allowed. It was that if you're carrying a gun with the intent, or you're carrying a weapon with the intent to cause terror, with the intent of, not engaging in lawful activity, then firearms can be prohibited. But that nuance seems to be left out of a lot of the analysis that I've seen.
Yes, it's conveniently left out of the analysis because they are not being honest with history. The statute of Northampton has been rejected numerous times by the Supreme Court as being an analogy to just regular peaceful carry. The regular peaceful carry of a weapon can never be a crime, because that's exactly what is protected by the Second Amendment. It's the right to bear arms and be armed for self-defense and for lawful purposes. The statute of Northampton really was more along the lines of preventing menacing, or let's say a guy's walking down the street with an unholstered handgun and, waving it at people. That's kind of activity, modern day activity, that would be considered analogous to the acts that were prohibited by the statute of Northampton. But really, when we're talking about crowded places bans, modern day crowded places bans, we're talking about a police power, right? And the police power is public safety mentality and interest balancing, and that's already been rejected by the Supreme Court. And Heller and McDonald and Bruin all made very clear that the interest balancing had already been conducted by our forefathers, by the founders, when they ratified the Second Amendment. And so unless there was something back at that time that was prohibited, it cannot be an analogy for the police power regulations of today. Like I said before, there were crowds back then, there were children back then, there were guns back then, there were other weapons that existed back then. And you cannot just, strip someone of their independent and individual right to be armed for self-defense simply because they're in a crowded area. It just is, they're conflating so many different things to try and justify their laws. And if we have honest judges that actually follow history and are honest with their analysis, then these laws will be stricken because there is no analogy.
And to that, I want to ask you because, again, the Supreme Court has talked about there needs to be a national tradition, right, that either should have taken place at the founding, that extended perhaps, into the ratification of the 14th Amendment, but that there needs to be that can't be a regional tradition, right? You can't depend on a couple of outlier laws, the Supreme Court has said. So to me, if the state of New York cites three or four rules from colleges, all of them in the Northeast, none of them predating the Civil War. That's not evidence of a national tradition. But we are seeing courts around the country say, okay, well, yeah, there was a territorial law passed in 1889 that banned, guns in educational facilities or, scientific endeavors. And then there was this law back in, the 1700s that banned guns at fairs. And those two things are close enough to serve as a national tradition of regulation against firearms in public spaces. Are the courts? Let me put it this way, because I don't want to speak in generalizations. What has your experience been when it comes to the court's definition of what a national tradition looks like?
I think especially in New York and in the Second Circuit, I think that the trend is to latch on to any court or any decision or any state statute that existed and try to make a case for a regulation and a historical tradition. Perhaps they leave the word national out. I think I'll have to go back, but I believe there might have been some language in the Antonyuk decision, the first one, possibly the second one, that spoke to a couple of outlier regulations. But the problem is that whether it's the district court or the courts of appeal, they can really just do what they want. I mean, they'll just grab onto something, they'll twist it, they'll make it fit, they'll justify it, and it's very intellectually dishonest and disingenuous because they're really not following the letter of the law. They're not being loyal to Supreme Court precedent or the Constitution, and they really just don't care. And it's going to stay that way until the Supreme Court does something about it. And unfortunately, that's the situation that we're in here in New York, is that, while the Bruen decision was under consideration, the governor and every town got together and came up with a plethora of locations that were outlawed, as far as sensitive areas, and nobody could arm themselves and protect themselves. And then now that those are being challenged, they're coming up with new regulations, and it's like swimming against the ocean, most times. But unfortunately, all of the responsibility lies at the feet of the judges. And if they're not going to follow the law, we're really kind of just stuck until the Supreme Court says otherwise, and in a very narrow way. Because, when, as we saw with the Bruen decision, when they started talking about licensing schemes in general, these anti-Second Amendment people will just grab onto specific language, and then the courts will then, I guess, ratify their interpretations of, language that's taken out of context and not really give full deference to the context and the decision from the Supreme Court.
Yeah, you're absolutely right about that. And it's one of the reasons why I think gun owners are so frustrated by the court's slow pace, let's say. I mean, they took two Second Amendment cases this term, but, the vampire rule in Hawaii, I mean, that really is an outlier law, right? And I understand that there's a circuit court split, excuse me, the Ninth Circuit, the only circuit to uphold a vampire rule, and they actually struck down California's, but upheld Hawaii's. And then, the other case dealing with 922 G1, unlawful, drug users owning firearms, that is an important issue. I'm not saying these aren't important issues, but there are other important issues out there, and the court has been reluctant to take on these hardware ban cases. They have yet to take on a sensitive places case outside of Wolford versus Lopez. Even as we see, the courts, including the Second Circuit, just engage in these torturous exercises to expand where these sensitive places can be. It is frustrating, and I think you're absolutely right. It is going to continue, unfortunately, until the Supreme Court gets very explicit about what a sensitive place looks like, what a national tradition looks like, quite frankly. And I don't know what is behind the court's reluctance to do that, but I do know that every day we don't see that from the Supreme Court. We see anti-gun politicians and activists use that inaction and use that silence to go after our right to keep and bear arms.
Right. It's really frustrating. And the people of New York have been patient, and God bless them. They're just, continuing, especially my clients, continuing to fight and to stay law abiding and to not carry in those places. That's because they're law abiding people, and really rules and laws, they're created for the evildoers. They're not created for the good people. So it's really just, there's no other legitimate reason for all of these laws except to disarm the population. I don't see any other reason for it, especially in New York, where everyone has to be licensed and vetted and go through at least a year, sometimes more, depending on your location, to even get a handgun license. I don't see any other reason for it than to just disarm the population, which is not a great feeling.
No, it is not. But I do appreciate all the work that you're doing there in New York State. I know that Second Amendment supporters across the country do as well. What is the next step? Where are you in the summer camp case? What's the what's next to happen, I guess?
We had just, I think in February, our motions for summary judgment have been fully submitted. I intend to file a motion to supplement the summary judgment record, because recently there was a Reddit post that was actually a video of some purported Israelis throwing kittens off a balcony in Israel, in the Palestinian area. And the first comment underneath it was specifically aimed and identified this summer camp, and there were questions about where is it located. We need to go there. We need to handle this. They're evildoers. So there was a direct connection made between whatever was happening in that video by whoever was doing it to this summer camp. And summer camp's going to be starting soon, and they're just very uneasy. And I'd like to supplement the record so that the court, because we do have an as-applied challenge, so I would like the court to be able to consider that this is just one more threat against the camp, to show that even if the facial challenge does not succeed, that the as-applied challenge absolutely should. So.
And by the way, these summer camps, let's say this particular portion of the Concealed Carry Improvement Act gets struck down. If a summer camp wants to ban possession of firearms on the property, they can, right? But it's just that right now, camps are not allowed to say, yes, if you have a concealed carry license, yes, if you have volunteered to be part of our security team, yes, you can do so. They're not allowed to say yes. But no matter what, property owners will be allowed to say, no, we don't want guns here. Exactly.
I mean, so many of the locations that New York State had introduced as sensitive locations are private places. They're on private property. The churches, the synagogues, religious places of worship, summer camps, preschools, daycares. So, just in other words, if you're leaving your house to drop your child off at daycare or to drop your child off at your summer camp, now you have to be disarmed, because now you're committing a felony if you go onto the property to drop your child off and leave. And so, yes, these are private locations, and they absolutely have the right to say, or post a sign saying no guns allowed, or we don't allow people to be armed on our property. And that's the other thing with regard to these historical analogies. There was no government rule or no government statute. Then these are not analogous to the modern day rules. But yes, private property owners always have the right to say that. Yeah.
All right. Well, Amy, listen, I appreciate everything you're doing. Really appreciate you carving out a few minutes for us today. And, you got an open invitation. When something happens in one of your cases, you want to talk about it, please let us know. We'd love to have you back.
Super. Thank you so much for having me. It's always a pleasure.
You bet, Amy. Thanks so much. Amy Bellantoni joining us here on Bearing Arms Cam and Company. My thanks to Amy for joining us on the program. Always love the conversations. And I do want to mention, going back to what I had referenced during the interview about John Lindsay and members of Congress in the 1960s, just sort of assuming that even minors had some access to their Second Amendment rights. I found the quote in this book, Gun Control, that I was referencing. This was in January of 1964. John Lindsay testifying before the Senate Committee on Commerce, and he said, among other things, certainly in framing gun control laws, we must think carefully about the constitutional aspects of the question. So, again, the assertion from gun control advocates, it just wasn't seen as an individual right until the Supreme Court invented it in Heller. Wrong. Again, this is liberal John Lindsay talking in 1964. In framing gun control laws, we must think carefully about the constitutional aspects of the question. Well, if it wasn't an individual right, then why would you have to think about that at all? Lindsay went on to say, surely there is no reason why we should prevent responsible adults or even minors from possessing licensed firearms for self-protection, hunting, target shooting, or gun collections. And then he went on to say, but it should be apparent that the unrestricted traffic in death weapons must be stopped. So, I mean, you get, oddly enough, you get both sides from John Lindsay in one quote. Yeah, the rights of responsible adults and even minors from possessing firearms for self-protection, hunting, target shooting, or gun collections, as long as they're licensed, right, which will then stop the unrestricted traffic in death weapons. So, again, my point is not, again, that 14-year-olds should get concealed carry licenses. Just that, again, even as recently as the 1960s, liberals like John Lindsay did not take issue with the fact that, A, the Second Amendment was an individual right, that there were some things that could be passed that would be unconstitutional, and that adults had the rights, in fact, minors had the right, to possess firearms for lawful purposes, including self-defense. Nah, I don't think you'd find a liberal politician willing to acknowledge any of those things today. At least not really. They might give lip service to that. Well, of course I support the Second Amendment. Well, what does it mean to you? I mean, that I can't answer. Much like we saw from the Democrats pushing gun control in the House Judiciary yesterday in Rhode Island. I'm happy to testify about the bill, but just don't ask me any questions about the bill because I don't know the answers, including the purpose of the bill, as one representative was asked. All right, on to today's Armed Citizen story, our good deed of the day, and our recidivist report. We will start there with a case out of Florida. The headline, bizarre break-in, woman crawls through window, tries to take dog. Yeah, a dog that was crated, by the way. If not, the dog might have actually put an end to this faster than police did. This was in Martin County, Hobie Sound, Florida. Martin County Sheriff's Office responded to the home on Tuesday evening after a call about a reported break-in. A woman who lives there said she came home from work and she could hear somebody moving around, and then she actually found a stranger in her home. Sheriff John Budensick says, all of a sudden, there's our suspect, front and center. And so they had this verbal altercation. The homeowner used some flowery language. What the bleep are you doing in my house? And he said, our suspect, our defendant, turned it around in reverse. No, what the bleep are you doing in my house? Budensick said there was a little bit of an exchange there. The victim noticed that her dog's crate and her dog had been moved outside. The dog is a German Shepherd named Glock. Thankfully, okay. Budenstech said outside they had a bit more of an exchange. Homeowner says she's calling law enforcement. Suspect then meanders down the driveway and leaves the residence. Sheriff said it's unclear at this point why she was trying to take the dog. He said, what was she going to do with a 90-pound German Shepherd? And then he said, actually, if you let the dog out, it might have fixed our problem for us. But what was she going to do with the dog? Who knows? I imagine nothing good. The suspect, identified as Roberta Walker, spent a half hour trying to break a window. The sheriff said that she chipped away at an impact glass window in the back of the home with a rock and a little piece of metal. And he said eventually she was able to compromise that window, at which point she crawled into the window. And that's when the homeowner showed up at the house. So this wasn't just, like checking the door. Oh, it's unlocked. I think I'll go inside. No, there was clear intent. A lot of time spent trying to break into that home. Sheriff's deputies were eventually able to find Walker inside a stolen vehicle in Stuart, Florida. She was taken into custody. Sheriff said when she was arrested, she also had a bunch of rings on both hands that she had apparently stolen. Walker, no stranger to the law. She was arrested last month in Palm Beach County after police say she stole a vehicle there. But apparently the state didn't file formal charges, which I would love to find out why from the Palm Beach County state's attorney. And the sheriff says that Walker also has a long criminal history out of Chicago, including charges of child neglect, aggravated assault, and theft. The sheriff says, we know she went from Chicago, somehow ended up in D.C., and then she's in Palm Beach County, and now she's getting arrested here in Martin County. So, but in this case, we have her sitting in our jail with no bond, and she's looking at serious charges. So, don't know what her past sentences looked like. If there were slaps on the wrist, if she actually spent some time behind bars, but whatever they were, not enough to keep her on the straight and narrow, because she is once again facing charges. And meanwhile, the homeowner, a dog named Glock, doesn't mean that she's a gun owner. Kind of assume that she's a gun owner, but it doesn't sound like the suspect here ever physically threatened the woman, or even gave the woman a reason to believe that she was about to be placed in a situation where her life was in danger. I imagine, and I'd like to think that if she did, it wouldn't be her dog Glock that she used, but rather her actual Glock that she could use in self-defense. And if the dog is the only Glock she has in the house, well, I'd say after this experience, that is probably likely to change in the near future. On to today's Armed Citizen story from Cleveland, Ohio, where the Cleveland Police Department has released video of a chaotic scene last December outside of a Cleveland church in which shots were fired in self-defense. 2 people ultimately got indicted in this incident. Happened outside the Church on the Hill of the Living Word. It was apparently an incident that started when a woman showed up without an invitation to an event that was being held at the church for her ex. And then the woman's brother shows up waving a gun around for some reason. The video also shows a woman making threats as she's put in handcuffs. The woman's name, Bobby Sullins. According to investigators, called her family members to the church, including her brother, Lamar Sullins. When she got there, I guess when he got there, there was a disturbance outside of the church. The pastor ended up shooting, I think it was Lamar Sullins, in an act of self-defense, according to authorities. The pastor got shot in the foot, according to investigators, and then he ended up returning fire in self-defense. Again, 2 people taken into custody, the pastor not among them. Prosecutors and police have already cleared that pastor. But remember, according to the anti-gunners, this pastor shouldn't have had a gun in a house of worship. If they had their way, this would be a gun-free zone. As written, the New York's Concealed Carry Improvement Act did not allow pastors to make their own decisions about whether or not they wanted to welcome concealed carry. Rabbis who, again, wanted to have, a synagogue security team. Not allowed unless they could hire armed security. Not allowed to have armed parishioners. That portion of the Concealed Carry Improvement Act was actually revised after litigation. And essentially says that concealed carry is allowed if it's okay with the property owner, right? But that wasn't their original intent. And that's not what the gun control activists want. They want us to be disarmed in as many locations as possible. They want churches and houses of worship to be sensitive places. They don't want pastors carrying. They don't want parishioners carrying. They don't want anybody carrying. The only problem is, while pastors and parishioners might obey that law, individuals with violent intent absolutely will not. Finally today, our good deed of the day, in the right place at the right time, willing and able to do the right thing. An off-duty sheriff's deputy in North Carolina who helped rescue some swimmers at Ocean Isle, North Carolina, who were caught in what sounds like to be a pretty bad riptide. This was over Easter weekend. Herbie Stubbs and his family were out there on Ocean Isle Beach. And he said that they noticed a man and two kids in the water that were clinging to a pier. And Stubbs says, well, we all immediately jumped in the water, not thinking about anybody else, but just trying to get these people out. So Stubbs, his son Chandler, his daughter's boyfriend, Marcus Coates, all able to help pull the two young kids out of the water. Herbie Stubbs said, I got one of the children, grabbed him, pulled him to me, and then I pulled him back to my son Chandler. We got him out. So they had a bit of a struggle rescuing the second child. Herbie Stubbs said he was so tired that, he'd been fighting and holding on to the pile of the pier. He said, finally, good Lord willing, I was able to get enough strength, and a wave or two pushed me up just a little bit. And he said, my son and myself, we eventually swam out, and then we were able to walk out with the young man, but he was so tired and limp, he said, we basically had to drag him off and get to the beach. Herbie Stubbs' daughter, Brianna, is actually a registered nurse, so she was checking on the boys when they were pulled out of the water. And he said the kid's uncle was also able to get out of the water safely. I don't know if he was able to do that of his own accord or if, again, one of the Stubbs family were able to help him out. But thankfully, everybody's okay. Stubbs, his son, and his daughter's boyfriend had cuts and abrasions from the pier, as did the two kids who were rescued. But, minor injuries, all things considered. Herbie Stubbs, by the way, says there's no way he could have done it by himself. He said, with the way the current and everything was going, no way. He said, I could have ended up in a bad situation. Herbie Stubbs, by the way, is a school resource officer with the Chatham County Sheriff's Office. Been with the office there for almost 20 years now. The sheriff of Chatham County, Mike Robertson, said the, quote, calm service mindset that Stubbs displayed on the beach also defines his work in schools. So in the right place, at the right time, willing and able to do the right thing. Deputy Herbie Stubbs there in North Carolina, we thank you for your very, very good deed. And I can tell you, just, firsthand, the riptides in the Outer Banks, nothing to laugh at. They are very, very serious. I think last time I was there with my family, the week that we were there were two individuals who actually drowned as a result of getting caught in the riptide and not being able to extricate themselves. So I think Herbie Stubbs and his family really did save some lives that day, and they hopefully are all going to be commended for that. All right, that is going to do it for this edition of Bearing Arms Cam & Company, and I want to thank you for being a part of the program as always. We'll be back on Monday with another program, but between now and then, be sure to check out bearingarms.com, because we are keeping you up to date on everything going on with your right to keep and bear arms. Again, extensive coverage of that hours-long gun control hearing in Rhode Island yesterday. No votes taken, by the way. A lot of testimony given, but no votes taken. And I I am cautiously optimistic that at least some of these bills, I think, are not going to make it out of committee. But Rhode Island gun owners, they turned out in force. I know they're going to keep up the pressure on lawmakers. If you are a Rhode Island gun owner and you're listening right now, call your state representative, call the members of the House Judiciary Committee, and urge them to oppose each and every one of these anti-gun bills, including the ammunition background checks, the mandatory liability insurance, obviously the ban on the possession of so-called assault weapons. But there are several other bills as well. You can go to NRA-ILA and find out more. But I would encourage you to get involved if you're not already involved, and to stay involved if you are. All right. Have a great weekend. Looking forward to seeing you again here in a few days. Until then, be well, be safe, and be free.